Hello, everyone, and welcome to the second webinar in a two-part series on how to ask employers and landlords for accommodation. Today's webinar is on asking landlords for accommodation and will feature discussions on understanding what the law says and how to request for accommodation. This series is brought to you in partnership in between the BLAC Legal Action Center and CLEO Community Legal Education Ontario. My name is Misha Hussain. My pronouns are she and her, and I'm the Learning Events and Community Engagement Specialist at CLEO. I'd like to thank my colleague Helen for providing tech support today. You can reach her in the chat under the name CLEO Webinars if you're having any technical difficulty. I would also like to thank our American Sign Language or ASL interpreters, Lori and Nicole, for supporting us today. You may notice that I pause after mentioning each name or location. This is to allow our interpreters time to sign the names letter by letter. I will also be doing this during the land acknowledgement when mentioning any names or locations. CLEO acknowledges that our office is located on the traditional territory of many nations, including the Mississaugas of the Credit, the Chippewa, the Haudenosaunee, and the Wendat. Today, this area of Toronto, also known as Toronto, is covered by Treaty 13 between the Mississaugas of the Credit and the British Crown. This land is now also home to many diverse First Nations, Inuit, and Métis people. CLEO commits to learning about and respecting the responsibilities and relationships reflected in these treaties, the Truth and Reconciliation Commission's calls to action, the calls for justice and to justice of the National Inquiry into missing and murdered Indigenous women and girls, and the United Nations Declaration on the Rights of Indigenous Peoples. We acknowledge the ongoing impacts of colonization, anti-Indigenous racism, white supremacism, and anti-Black racism on which the city and our legal systems are built. We are all treaty people, and we commit to working in solidarity towards truth and reconciliation. We also remember those who were brought to this land involuntarily, particularly those who came as a result of the transatlantic slave trade. So we also honor and pay respect to the ancestors of the African origin and descent. So what can you expect today? So this webinar will be 90 minutes long with a Q&A period at the end. The webinar may contain legal information, but as a reminder, this is not legal advice. The information is current as of today's date, which is October the 15th, 2025. The links to the recordings and slides and the handout will be sent by email to all the registrants within a few days, so please keep an eye on that. ASL or American Sign Language interpretation is available for today's webinar, and the subtitles have also been enabled. So if you have any questions about today's content, please use the Q&A box to submit them. We kindly ask that you keep your questions general, as our speakers are not able to provide advice on individual or personal situations. This webinar series has been funded by the Law Foundation of Ontario and the Department of Justice Canada. Although it is financially supported by the Law Foundation and the Department of Justice, the speakers and CLEO are solely responsible for all the content which is shared today. So as for our speaker today, if you are joining us for the second time, we have Demar, Kemar, Hewitt, who is the Executive Director and General Counsel at the BLAC Legal Action Center. Demar is admitted to practice at the bars in Ontario, Alberta, and Jamaica. Demar completed his studies at the University of the West Indies, University of Technology at Norman Manley Law School, and the University of Toronto. During his time, he's no stranger to community work, being involved in a number of human rights litigation and administrative law matters. This foundation shaped what would become his legal practice. Until his appointment at the BLAC Legal Action Center, Demar represented the interest of Black families and community organizations at Corners Inquest. So thank you so much for joining us today, and I will hand it over to Demar to take away the presentation. Thank you so much, Demar, for being with us today. We look forward to learning from you.
Thank you, Misha, for that introduction. Welcome to everyone joining us today. So if you're joining us, this is part 2. And just a little correction on that slide, you should be asking your landlord for accommodation. So in part 1, we dealt with employers. Now part 2, we're dealing with landlords. So just so you understand the flow of the presentation, I will ramble on for the first 40 minutes or so, I believe should be enough to get me through the content. And then the second half of the presentation, I'll take your questions. So as Nisha said, as the questions pop up, post them in the Q&A, and then we will take them as much of them as we can in the end. So I think I've allotted sufficient time for that based on history. All right, so we'll jump into it. So Misha flagged that we'll see on the other slide that we're talking about human rights matters here. Of course, some of the content can be triggering, can be sensitive. If you need to take a break, do that. We have on screen resources, and Misha will share some additional resources available to you at the end of the presentation as well. Okay. Now, on the next slide, you will see the usual disclaimer that we've given. This is not legal material. Some of the scenarios that we're discussing, they're fictional, really, and not intended to represent a particular client's situation. All right. Now, we'll jump into the content of today's information. So here's what we intend to go through. So before we get into the discussion, I'm going to walk you through the basics so we understand the concept of accommodation in the housing context. Today, we're focusing on housing. And then we will walk through some general tips when you are requesting accommodation. And those include initiating the process to request accommodation, information that you might be useful for you to include in your request. And when we're constructing the request, we're keeping in mind the obligation of the housing provider in relation to their procedural and substantive accommodation duties and what the entire concept of undue hardship, what that looks like. So on the next slide, we get through the basics, and I just give you a little bit of background here. When we're drafting the request for accommodation, it's what we would call in lawyering as perfecting the record. It's not really intended to be perfect, but what we're trying to do is to lay the foundation. So if your request for accommodation is denied, then and you're challenging the denial later on, you want to make sure that you had given sufficient information that would have compelled your landlord or housing provider to exercise their duty. And then you have a really good basis on which you can challenge that the denial of accommodation is in breach of your right or their duty to accommodate you. Okay. So the legal framework that we're going to go through is primarily based in the Ontario Human Rights Code. There are other legislation that will chip in when you are dealing with housing matters. For example, the Residential Tenancies Act, the Accessibility for Ontarians with Disabilities Act. All this legislation do come into play. And while today we talk primarily about landlord and tenant relationships, you should know that the concept of accommodation under the Human Rights Code applies to many different housing arrangements. Okay, so generally we talk about rental. The only exception that's usually carved out are situations where you are sharing a space with your quote-unquote landlord. Those situations are usually carved out when you're talking about accommodation under the Human Rights Code. But co-op housing, your usual landlord and tenant arrangements, or generally impose an obligation on the landlord to accommodate. Okay. So under the Ontario Human Rights Code, you have the right to equal treatment and access to housing. And access, we generally talk about if you want to rent a home or buy a home, you should not be treated differently because of one of the protected grounds. There's several protected grounds, many intersectionalities, 19 of them, depending on how you count just the general counts. And when you start to add intersectionalities, it's endless. You have the right to be free from discrimination. And we spoke about the application of these rights. And then when we talk about the duty holder, that's the quote unquote landlord, which we're going to use loosely throughout this presentation. The landlord has a positive duty imposed on them under the code to do what is necessary to advance the rights that you are entitled to. And that duty includes within the housing concept or the housing context, the duty to remove barriers, whether that's a physical barrier, a procedural barrier, or some other policy-related barrier, ensure that those are removed so that you can enjoy the rights that the code has bestowed on you. So on the next one, we jump into the general right to accommodation. Well, sorry, the request for accommodation. So here's what that request looks like. And this is where we're going to start laying the foundation for what you can expect when we're having that discussion. So when you're requesting accommodation, accommodation must be based on a need. And so the first thing you want to do is to identify your need. And it's also useful for you to identify the ground in the code that you're relying on to establish that need. All right, so let's walk through the practical examples of how that is. We generally suggest that you make a request for accommodation in writing. And writing could be via text message, via an email, some other form of application, or even the old-fashioned way of writing letters. But we suggest writing because the time of making the accommodation is usually important. And written forms are just the best way of proving when you actually made the request. Remember that if you're going to be challenging the denial or breach of the duty to accommodate, that has to be done within a year. And so knowing when avoid the dispute as to whether or not it was made on this day or that day, we generally suggest that there's something in writing, okay? Now, identifying the need. Here's what you would put forward to identify that you have a need that requires accommodation. We generally say, depending on the type of need, you are looking at some form of externally reliable evidence where the need is not obvious. So if you've been with us for a few times, you would have heard, if the need is obvious, the general principle is that you need not give any additional documentation. And what do we mean by it being obvious? For example, if someone uses a mobility device to attend the interview for housing, all the time they've been living in the house, they've been using mobility devices, walking aids. If the landlord can obviously see that the person recently had an injury, their circumstances have changed, and now they need additional assistance to get around the house. Things that are just general knowledge or you can plainly see. The request for additional information in that case, or the need to provide supporting information in that case, is usually very low. Okay. Now, the information when we say should be from an externally verifiable or reliable source. So a doctor's note, for example, speaking to the disability, a therapist or someone else involved in your circle of care. Now, you want to make sure that when you're requesting, the burden is on you to prove the need. And so you want to put forward the best evidence you have to prove the need for accommodation. And so If you're looking for something that is a physical modification of the living environment, for example, you want to rely on the person that's best able to give you that sort of evidence. So any sort of assessment that needs to be done, either by your social worker, for example, your occupational therapist, someone who your nurse that visits your location, provides care to you, and is able to put forward to your landlord the modifications that are reasonable so that you can enjoy the premises that you currently live in. So that's what you're looking on. In circumstances where a doctor's note is quite capable of giving the information, then it might just be a doctor's note that you're putting forward to confirm that you have a disability. And that's all the things I rambled about a while ago is confirming that you have a disability. And that's what the first thing you must do. There's some information, of course, that is unnecessary. And if your landlord asks you for it, certainly it can be seen as being overly broad and intrusive. And overly broad and intrusive includes information that is beyond the basics to confirm to the landlord that you do have a disability. For example, I would declare to the landlord that I have a mobility issue where I'm unable to walk and I use a wheelchair. It is not necessary for me to tell the landlord the exact diagnosis. What caused me to be unable to walk freely? It is unnecessary for me to tell the landlord all my medical conditions, and I cannot be required to give to the landlord my full medical records. It is necessary for the landlord to know what the disability is, and that's my mobility issue. The rest of my medicals that lie behind it, it's not for the landlord to have that information. So if you get that the landlord is asking you to get into your medicals, it is overly broad. They're not allowed to request that information. Okay. Now, the next thing that you have to do is state your limitation and the impact on you. So I have this disability. Here's how the disability affects me within my housing context. So you will give details as to the functional limitations. For example, I'm making a request for modification to the home because it has these stairs and I can't climb stairs. Or the entry to the home requires me to go up a certain number of flight of stairs, even if it's 1, 2, or even 4. And I'm asking for a ramp to be installed so I can access the home because of my particular disability. You will give some information whenever you're requesting your note from the doctor or the therapist, and you'll see this coming up at different points. Whenever you're requesting your notes, your doctor's note, for example, you will want to make sure that the doctor touch on these things, right? So in addition to saying what your disability is, giving some indication to the landlord as to what they can do to accommodate you based on your disability. So the doctor will give that little hint, or the therapist or whoever will give that little hint in their letter. There are circumstances, for example, what I pointed out, where the need for accommodation is plainly obvious. And one of those circumstances is you have an accessibility parking permit, for example. So if you're requesting accommodation to be situated in a particular location, a closer parking spot, to be able to use 2 parking spots instead of the 1 small parking spot that you ordinarily assigned to, for example, in a condo or apartment setting. Providing your parking permit, that's usually evidence that you have a disability that most likely will require some accommodation. And when it comes on to driving and maneuvering vehicle, parking accommodations is the most usual one that will come into play when you have what we call a disability permit. Okay? So I have made that request. I have stated what my limitations are. What information can the landlord not ask me for? Or if they ask me for it, I can't say that is overly broad or intrusive. I should not be required to prove or demonstrate that I cannot walk. I should not be required to prove that I need a walking aid to justify why I got my disability permit, for example. It's sufficient that I have given you information, and even more so if the information is from a reliable third party, that I have that disability. If I have given you my disability parking permit, that's an independent third party, reliable source that this person has a disability that qualifies them to receive this permit. I should not be required to prove to you that that is actually so by doing any particular physical test. I should not be required either to attend to any place and do any particular specialized test to prove to you that my disability is genuine. Again, if you're thinking reliable third-party evidence, that's usually as high as you can go. Well, that's usually sufficiently high, put it that way, because you can always go higher. But the landlord cannot compel me to attend their physician or their therapist to test, whether or not it is reasonable for me to be claiming that particular disability. Okay. Now, once you have stated your accommodation need, you have put forward the limitations. Now you need to link the two. Based on my disability and based on those limitations coming from the disability, here is what I'm asking you to modify. And this is where you now make the link. So let's go back to some of the examples that we've had. If it is that I'm required to go upstairs to get into my unit, but I'm asking you to make some accommodation, it could be that instead of having me in a higher level unit, the request that I'm making is for you to transfer me to a lower unit where I do not have to navigate upstairs to get to my unit. And the accommodation request that you're making certainly must be, first, one that allows you to overcome the barrier that is imposed. So that's the first thing. But also keep in mind that the landlord can say no if it leads to undue hardship. I don't know why I started on that a while ago. So if what you're requesting, it will be unduly hard on the landlord, keeping in mind the cost and funding options and all of that, the landlord can say no. So your request, you want to make sure that it meets your needs, but it is reasonable, quote unquote, or not unduly hard. Unduly hard is a high burden. It requires great thought and consideration, right? So if you can show that you are requesting something reasonably, then you're on good footing. If, for example, I have my parking permit, or even if I don't have a parking permit, and I recently had an injury that has now caused me to have a disability, and so I'm requesting to park closer to my unit. If I'm requesting to switch parking spots from one where, it's not so conducive based on my new mobility needs or new mobility requirements, then that could be the request for accommodation to be at a closer spot. All right. If it is that there's a particular ramp and it's easier for me to get out, get in my mobility device and get up the ramp, then it could be I'm requesting to be placed closer to that ramp. Of course, keeping in mind that these options are actually available, right? So the landlord will take into consideration that somebody might already be receiving accommodation to use this particular spot, and so I couldn't reassign them to you. So just keep that in mind. All right, and then what information can the landlord request? So now that I have indicated what the accommodation I need, they can request from you specifics that will assist. They want to know, when I give you the accommodation that you're requesting, how does that help to eliminate the barrier? And so even before they are asking you this question, you want to make sure that you're laying that out in your request for accommodation. So I've said what my disability is, all right? I've said how that limitation or the limitations from that disability impact me within the context. I have linked to show you how this is the accommodation I need to address that barrier. And this is how the accommodation will assist me in overcoming these barriers. So anything that's reasonable to assist the landlord in making that determination as to how you will overcome the barriers based on the disability and the limitations, the landlord can ask for that information. But what they cannot ask for is for you to come up or give them some plan as to when it is that you will overcome your disability. For example, you're not required to give evidence as to the treatment you're receiving to overcome your disability. You're not required to commit to a particular arrangement for a set period of time, assuming that your disability would have been resolved within that period of time. Because what the law requires is that you continue to receive accommodation to the point where it is no longer required on your end, or it is unduly hard on the side of the landlord. So you're not required to commit ahead of time to say, okay, I'll be giving you the accommodation for 2 months and that's it. You're not required to take that position. But if your medical professional says, of course, 2-month period is reasonable, will be reassessed then, it is okay to have a plan in place for 2 months, subject to, of course, reassessment, because you will do that reassessment and determine whether or not you need to extend it for an additional period of time, right? Now, here is where we talk about undue hardship. And undue hardship is that get out of jail free card, quote unquote, that landlords try to rely on in determining whether or not they provide you the accommodation you are requesting. And so when you are making a request for accommodation, even though it's not strictly necessary, you want to make sure that you put forward, or it's helpful for you to put forward certain suggestions as to how it is that the landlord can provide you the accommodation. For example, if it is that you're asking for something that you're quite able of contributing or sharing the cost, you can certainly put that forward. And let me just say, the undue accommodation requires the landlord to consider a few things. The cost of it is usually the most pressing one for most landlords. So the cost of the accommodation you're requesting, they will take into account any health or safety concerns based on, the requirements of the building, generally speaking, making sure that if they erect a ramp or some form of solution for you, it will not become, for example, a fire safety hazard. It will not be in breach of any rules or regulations that are imposed by law or bylaws at the city level. They will ensure that whatever is permitted is something that that you're asking them to do, right? What you're asking is not something that is otherwise should not be sanctioned, put it that way. So that's the first. And then, of course, the landlord would also take into account external funding options. And when we say external funding options, it means it could be you. It could be how you're contributing to the process. Are you receiving a grant from the city or from someone else to assist in putting these in? Is there a company, for example, that will sponsor your chairlift if the landlord authorizes the installation? This is the kind of information that you're putting forward to say, I'm requesting these things. This is how much I anticipate that it's going to cost. And you get that price from a general Google search, or if someone is assisting you, a contractor's quote. This is how much it's going to cost. This is what my contribution is, or this is what the sponsors are willing to give. And so this would be the cost on your side, if there is a cost at all. And you see, I have this set off because you can recommend that I will do these as my contribution to the accommodation. You're not required to, of course, lay out any particular thing to receive accommodation. But if it is that you can show that you are in good faith participating and willing to contribute, it's not a higher burden, but certainly it will go more against a landlord, where it can be shown that you have been more than willing to meet the landlord halfway in discharging their duty to accommodate. Because the duty to accommodate is theirs, it's not you. But I'm even doing above and beyond to meet you halfway, and you are still saying no. Okay. I'm doing good with time. All right, so on the other one, we are just keeping in mind a few of the things that the landlord has in their minds, or the landlord has in their mind, or landlords, when they are inquiring or they are assessing your request for accommodation. So the accommodation comes in two parts. There's a procedural accommodation and there's a substantive accommodation. Procedural accommodation, whenever you say to the landlord, I am requesting accommodation based on my mobility disability, the landlord has two options. They can accept that you have a need that requires accommodation, or they can investigate in good faith. So two things happen. I take you at your word and move ahead and try to accommodate you or determine how I can accommodate you. Or I can inquire. I am not taking you at face value. I'm requesting additional information, or I'll go through the information to see if there is really a need. The law gives the landlord both options. So if you have provided information and you're satisfied that you provided the information, don't take it that the landlord has denied or is questioning the authenticity, quote unquote, of your disability because they're asking for more information. It is two options that the law allows them to exercise. So they can accept or investigate. Now, let's just, if they accept, you jump to stage 2. Nothing else needs to be done in stage 1. But if I'm going to investigate, then they have a duty to ask all the relevant questions to gather all the relevant information. Relevant, of course, is based on the context in which you are living and operating. So it's based on the disability you have. It's based on your living environment. It's based on all the socio-surrounding circumstances within your arrangement between you and your landlord. So that's what's relevant. It might be a different relevance. The relevance in a situation where you are living in a social housing, for example, might be different than when you're living in a condo, where the landlord owns only that particular unit. They have no control over the common areas to enter the building. Those circumstances, the relevant information is going to be slightly different than where you are in city housing, for example, where there is one landlord in charge of everything, right? So just keep that in mind. Then, assuming that we now get past procedural accommodation, and we should get past procedural accommodation in any event, we now go to substantive accommodation. And this is where the landlord is now engaging with you, trying to work out what is reasonable within your circumstances to provide you as accommodation. Now, keep in mind, the landlord is not required to give you exactly what you want. They are going to accommodate you reasonably. That's the standard. The landlord has to determine whether or not they have a duty to accommodate you. And the duty generally arises because the need is obvious or has been proven, or I have given you sufficient information to show you the need, to show you the limitations, and to link the two. So the duty is triggered once I have made that inquiry and I've given you all the information. And then once they have determined that there is a duty to accommodate, there is a need to accommodate, what that accommodation looks like. How much of that accommodation can I give? Can I give a particular percentage, or can I give none? And that's where they are now at that point of undue hardship. And remember, undue hardship is where they now look internally based on the cost of doing that accommodation, based on their resources, the funding options, and all this health and safety requirements, they determine at that point whether or not they have met the bar for undue hardship. Now, undue hardship is certainly not impossible. It is something that can be met, but it is a high bar. Okay. Now we jump over to the no pet policies. And we've been talking so far about physical accommodation, and I should flag that there are many types of accommodation that you can request. Physical accommodation are the ones that we are most used to. So we talk about those, on a day-to-day basis. But it could be an accommodation that requires an adjustment to a policy. For example, if it is that you have a policy that speaks to you having to earn a particular income, or you to have a particular family structure, or what family structure may have been contrary to the code in any event, but particular income requirements or a period of time residency requirements, all those things that are in policy, you could be asking for those to be modified to accommodate you based on your needs. It could also be an accommodation based on policies against pets, and that doesn't require a physical amendment to the premises, but you're asking for an adjustment. So we have the physical, we have the policies, and many different types of accommodation you could be asking for. Accommodation based on your religion and creed, accommodation based on your family status. But if we look on the no pets policies, which is probably another usual one, once you have established that you have a need, for example, I have a disability, I have a service animal that assists me in participating as fully as possible and enjoying the needs of society, then no pet policies ought to be modified to provide you with that accommodation. So it's not uncommon for you to be in condo buildings and, those common areas where there are restrictions on having pets in those areas or having pets in the buildings at all. But once you have shown that it is a service animal and you prove your disability, then you would have laid the groundwork of the need to be accommodated. So the information that you would put forward, again, the proof of the disability and the linkage, you'll do that. But because you're talking about a service animal here right now, the registration for the service animal is something useful that you put forward. It is not determinative that you have not provided the animal's registration, so I will not accommodate you. No, but the presence of it is also evidence that you have something that requires accommodation. There is a need. Otherwise, you most likely would not have been assigned a service animal. So someone, a third party, has already done their assessment and found that a service animal is proper in these circumstances. Information that the landlord is not required to provide you, not required to get from you, is proof of training. I'll flag that for you. Proof of training is technically not required when it comes on to a service animal, but we have recognized that there are some breeds of animals that are particularly dangerous. So it is not unreasonable for a landlord to ask for some clarity to ensure that allowing a particular breed of animal in a common area as your service animal would not in and of itself pose a risk of safety to others within the building. Accommodation is generally individualized. So we're looking at how the accommodation applies to you. The landlord are not to be concerned with how somebody else feels about you getting accommodation. That plays no part here. But the landlord is required to look to the health and safety of everyone else around you as to how your accommodation meets the established health and safety guidelines and requirements. And so to that end, a service animal that is of a breed that's known to be rather aggressive, that recent history is showing that these animals are acting out and causing harm, then the landlord could ask you for, what the safety net looks like. Okay. But if it's not something that is ordinarily within what you can obtain, for example, we don't have a certified training animal agency here in Ontario, so they shouldn't be asking you to get any sort of proof or certification that this animal will not act out at some point and cause harm. Okay. All right. So I believe that takes us to through the basics of the presentation. And now, just about shy of the 45 minutes I thought I would have, we will jump into asking the questions.
Thank you so much, Demar, for your presentation and for sharing so much information in such great details. So we do have several questions in our Q&A box, which I can address one by one. This is just a reminder to everyone to please keep your questions general so that we can address it. So the first question that we have for you, Demar, is how can one demonstrate harassment by a landlord in an accommodation situation?
So harassment requires a series of unwelcomed conduct. So conduct that the landlord knew was unwelcomed or ought to have known to be unwelcome. So it does require a series. I would flag for you that harassment, and I've seen this quite a few times, the landlord asking you multiple times to do something that you ought to do is not harassment. So, for example, the landlord asking you, where's my rent? Week after week, every day, even 4 times a day, is ordinarily not seen as harassment. And the reason for that is it's an obligation that you have, and there's an anticipation that you will perform your obligation. And you would have anticipated that if you don't pay your rent, the landlord would be asking you. Remember, it's conduct that is unwelcome or ought to have been known to be unwelcome. You know I'm going to ask you for the rent, so that's not harassment. How do you prove harassment, though? By doing the opposite of that. Something that is unwelcome. For example, my landlord smokes, and the smoke gets into my room or my living area. I have spoken to the landlord about addressing the smoke. And since that the landlord either continues to smoke, that's conduct that is known to be unwelcome, smoke in the house and gets in there, plays loud music in an attempt to drive me out of the unit, or anything else that the landlord can do to show that they intend to make your life uncomfortable being there, that would amount to be harassment intended to, cause you to take a particular course of action, for example, or otherwise make your life a living, I don't want to use that word, make your life very, very uncomfortable.
Difficult.
Yeah, and difficult. So that is how you prove harassment. Now, I want to flag for you though, harassment, if you're talking about code-based harassment, now keep in mind that you first have to have a code ground that would have been triggered. So if you're saying that the series of unwelcome acts are based on your request for disability accommodation, then that's a code-based harassment. If the unwelcome acts are based on your request for maintaining the unit, that's not a code-based harassment. So let's just make the distinction between the two. That's harassment that would be triggered from enforcing your rights under the Residential Tenancies Act. All right. But in this case, we're talking about code-based harassments where you have a protected ground, you sought to enforce your rights because of that ground, and then the landlord is taking a series of acts against you. Now, I should say the question said, how do you prove against the landlord? And I'm assuming that the landlord is the one that's performing the acts. But I should also flag that it could be a tenant that is doing the harassing acts, but the landlord has a duty to protect you from that toxic environment that's caused by the tenant's harassment. And so the landlord can still be liable in those circumstances. Okay.
Thank you, Demar. Another question is, when a parking permit has expired because an individual does not have a family doctor to renew it, and this is a disability parking, I think, can an older disability parking permit be used as proof?
So I will say, I'm going to say yes. I'm saying yes because a valid permit is probably the best evidence. But the fact that my permit has expired does not mean I no longer have the disability. So the landlord still has a positive duty to, if they do not accept that I have a need based on an expired permit card, then they have the duty to investigate to see whether or not my disability continues, whether or not the need for accommodation continues. So it would not be proper to simply deny the request for accommodation because your permit has expired. It could be that I no longer require a driving permit or I no longer qualify for the driving permit. And if you recall, to get the disability permit, parking permit, requires you to be unable to walk a particular distance. If I remember, it's been a minute since I've read that legislation, so forgive me. It could be that I no longer have that limitation of walking a particular distance, but the rest of the disability could still be there. So I don't get the driving permit, the parking permit, but my disability is still there. And that disability still requires accommodation.
Thank you, Demar. Another question we have is regarding mobility devices. So this is with regards to lithium battery mobility device and fire risks. So how can a tenant overcome a landlord's fear of health and safety issues? So the person who's asking the question has spoken to someone whose landlord would not rent a unit to them due to them being a user of a lithium battery powered mobility scooter.
Very technical one, because the landlord is denying your request for accommodation based on your limitation and the equipment necessary for you to overcome the barriers of your limitations. So on the face of it, it does sound discriminatory. The question is whether the denial can be properly grounded in undue hardship. And I'm going to say no. Because yes, there is a safety concern when it comes on to lithium batteries. It is documented. There are restrictions as to where you can take them. You know, we know in certain public vehicles, they're no longer because of the fire risk, hazard, and entrapment issue. So they're going to say no. But there are alternatives. So is it a situation where your mobility device can otherwise be secured? You use it up to a particular place, you store it in a particular place, you transition from that device to another. Are you able to remove the batteries at certain points so that it is no longer a fire risk? Do you only charge it in a particular area that if there is a fire or there's a low risk of fire. But if there even is a fire, the fire is contained, or do you, for example, impose certain fire mitigants or fire alerts in that area where you store these particular um, devices. I would say that there is some risk. The existence of some risk doesn't mean that you successfully get to claim undue hardship for health, for safety. I'm not sure that the evidence is there yet that across the board, lithium battery devices are hazardous and should be completely banned. They haven't been banned, even though there's some signs that, restricted in certain areas. So I believe there are a lot of ways of getting around that issue, and to simply deny it because the battery is lithium would fall short of it's completely discharging the duty to accommodate.
Thank you, Demar. Another question that is with regards to health. So, can you discuss if a tenant has a request for accommodation for medical cannabis to their landlord? What would happen in this case with medical cannabis?
Tricky one too. Cannabis, so many bylaws were once against cannabis use in a unit, but it is now allowed. I'll say this. So the general accepted position on medical cannabis is cannabis within the confines of your unit is generally allowable. So there's that. In the common areas, no, it's not. Because in common areas, you are now imposing on other users of the common areas, but within your unit, yes. It is not unreasonable, though, for general safety reasons, for the landlord to, if you're smoking medical cannabis, I'm saying there are other ways of consuming medical cannabis, but I'm assuming smoking. If you're going to be smoking, for there to be a designated smoking area. So medical cannabis is medicine, like anything else, but with just that additional fire risk that comes with it for smoking it. So you could have a designated area where you could smoke your cannabis without affecting or otherwise impacting the rights of other users of the common areas. So that's one way of getting around that. But because of health and safety, generally speaking, I'm thinking that a landlord would be entitled to put in place some restrictions on how it is that you use that fire and smoking within the particular unit, especially where your unit is connected to other residential units. But the landlord cannot deny you, for example, taking you as a tenant only for the reason that you smoke cannabis, right? That would be discriminating against you because of the needs of your disability.
Thank you. One more with regards to health and accommodation. Um, this is with regards to someone being deaf, and this being an invisible disability. A deaf person may need accommodation for home, like installing visual alerting system in the home. Would this be seen, would be able to see, for example, the person would be able to see flashing lights when there's a fire alarm activating? How would a deaf tenant ask their landlord to provide installation of the visual fire alarm in their home? This may be too expensive for the landlord to install. And is that something the landlord can cover, or would ODSP cover if the tenant is on ODSP? If you
Okay.
would know.
The ODSP part, I'm not familiar with as to what they would cover. I say this, the question is, how does seeing the flashing lights and all of that assist the tenant in overcoming the barriers to enjoying the unit? It might be a harder one to link. Now, bear in mind that you establish your disability, which is hearing impaired. You identify your limitations, which is, I guess, unable to hear noises, the usual things around you. The linkage, though, might be where this one is missing. Seeing that flashing light so that I can that I can overcome the barrier of it. I would say this, the imposition of flashing lights, what flashing lights themselves are within most fire and carbon monoxide detectors nowadays. And if I recall, those are generally maybe if it gets to $100, maybe slight over. And I'm just using it because I haven't purchased one in maybe a little bit of a while. So because it is now attached to these things, I'm supposing replacing your old fire alarm with that kind of fire alarm gives you a flashing light, because that's one of the reasons for it being there. For persons who are unable to hear the audio signal, they'll see the light, flashing light visual signal. So that could be one way of getting over that hurdle, and in a way that is not overly expensive to a landlord, because I am almost sure that signal does not exceed $200. So that could be your suggestion.
Thank you, Demar. And this is with regards to a disability that has to do with mental health. So if a person is requesting for accommodation on the basis of mental health, and in a particular situation, for example, they have difficulty moderating emotional responses, and they would like to have communication in writing, uh, as opposed to, let's say, verbal interaction, how can someone go about that, and how can they request that accommodation?
The same way you request all other forms of accommodation. Very good question, because I know we tend to focus on the physical modifications and the other forms of of accommodation that do exist. That could be methods of medium or methods of communication. It could even be methods of paying your rent, depending on your particular circumstances. So accommodation is really a broad spectrum. So I'm really happy for that question. It is the same way you request other forms of accommodation. You would be putting your accommodation in writing. In this case, you say writing is your preferred way of doing it. You will be identifying the need to accommodate the limitations that triggers the request for accommodation, and how doing it that way will continue to allow me to enjoy my premises. And that's one that you would be able to link relatively easily, because you do have the right to peaceful enjoyment of your unit. And where it is that you have persons within your space, makes you anxious and, triggers your disability, then requesting some form of accommodation where it is simple, it doesn't cost the landlord anything at all to convert to writing, at least I'm thinking, it's minimal cost. That one would be difficult to plead undue hardship and deny that I will continue to talk to you and I won't be writing to you. So
Thank you. Thank you. Another question is, this is also health related. So it's not particularly written if it's regarding rooming housing or if it's like an apartment complex, but if a tenant is allergic to secondhand smoke and they have chemical sensitivity, and there is another tenant maybe within the same premise who is smoking, what kind of accommodation can the tenant that who has the chemical sensitivity request from the landlord? And yeah, what are the limitations?
So the limitations and that goes back to the early discussion we had, where the landlord, keeping in mind the accommodation requests or the accommodation they are giving to other tenants. And so they can't take accommodation from one tenant to give to the next tenant. That's not allowed. They have to find a way of accommodating the new tenant or the new request to the point where they can't accommodate anymore. It's unduly hard. In a particular case where you have a tenant next door, we don't know if they're being accommodated by their smoking, but you have your disability. One way the landlord could do this is, for example, as we said, a designated smoking area. So you smoke in a particular area that is within reason shouldn't disturb the other tenants or shouldn't trigger the disability of another tenant. So they may not allow smoking in the unit. It could be on your balcony, depending on the setup of your place, or it could be you smoke at a particular area and you have an extractor that will pull the smoke and pushes it away from the building. And you have to turn on the extractor every time you go into that particular area to smoke. It could be a smoking room, and we've seen that already, which is just a makeshift plastic, for example, that you buy on Amazon for a couple of dollars, put on your balcony. And that way, the idea behind it is to keep the smoke contained in that room when you're smoking in an area where it's likely to drift over to other units. So you enter that room, you smoke, and the smoke is contained there and it filters out. So that's one way of doing it. You could ask your landlord to, do any of these because certainly you have the right to continue to peacefully enjoy. And your request for accommodation would be that the landlord takes the particular steps to address the smoking coming from the other unit, because you have a disability that is triggered by this secondhand smoke coming over. I will flag that within the context of shared housing, and when I say shared, I don't mean as in sharing a particular room, but where you have units that are joined to each other, like in a condo or in many apartment settings, where you have residential units so closely joined, they're really juxtaposed. A little bit of inconvenience is anticipated. And they call those the general noise of living. So the noise coming from the next unit, smells and smoke and that kind of stuff from ordinary use of the next unit, that's expected. So getting some level of that discomfort, and the landlord is saying that what is happening is within the ordinary use and they can't do anything about it. That is allowed, right? Because we won't have a perfect living environment when we're living so close to each other. It's different though, in where you have a more clearly defined spaces where you can venture out, consume your smoking and anything else like that. Then though it might be harder for the landlord to say, there's nothing I can do, when it's clear you have a very big backyard, you can designate smoking to be at the back of the premises. Okay.
Thank you. The next question is, if a tenant no longer has a family doctor and they suffer from chronic pain due to a long-term health condition, will a letter from a secondary healthcare professional, for example, a chiropractor or a naturopath, be acceptable when they are requesting for accommodation? And or would it have to be like prior treatment, some form of documentation or medical files that they would have to provide?
Okay, so we remember we said it. Medical files are a no-no. No need to put your medical files. No need to put your treatment information either. That's a no-no. Any person within your circle of care is generally accepted to be an independent third person with sufficient knowledge of your situation that can give the evidence to support your requests for accommodation. Well, to prove your disability, because that's really what they're doing. So the question, and the usual test is this person within a regulated field? Now, I will tell you that I have seen online colleges relating to naturopaths. Are they regulated? I don't know. I have seen case law challenging the use of certain of these words, like association of so or college of so, that gives a particular impression, but they're not regulated fields. So I don't know if a naturopath is a regulated field, but if they are, then yes, they should be able to give some evidence towards your disability. Now, remember, the person that is best placed to give that evidence is the person who would be capable of diagnosing that disability. So when it comes on to mental health, then you're looking at a psychiatrist, or psychologist deals with the treatment, psychiatrist deals with the diagnosis. I always get those two confused. Your doctor is out of the way. So the question is, can you get a walk-in clinic or a nurse, your social worker, anybody else that's within a regulated field, assuming that your naturopath isn't a regulated field, but somebody else within your circle of care. But even if they're not within your day-to-day circle of care, can they do an assessment of you and then come up with a treatment plan? And that assessment could be, I don't know, a week, 2 weeks, whatever is reasonably sufficient for them to make that determination. But it doesn't have to be your doctor. It is the person that is best placed to give that information that I would go to. So in some cases, it's not my family doctor because somebody else can give a better evidence or account of what my disability is. And if you don't, you still make that request for accommodation, putting forward your best information. And it may also include the fact that my family doctor has retired and I am searching for another family doctor. But until then, these are the details of my disability. These are the details of my limitations, and I'm asking you to properly consider it, even in the absence of a medical doctor's report or doctor's note.
Thank you, Demar.
And I'll answer that question because there is case law on the point that you cannot be compelled to provide information that is outside your capability of providing. So if my ordinary doctor is retired and within that few months, I'm still searching for a doctor to give me treatment, and the closer doctors I have around me are not able to see patients until 2 months down the line, it's really difficult for me to get you any information within that 2-month period. But you shouldn't deny my accommodation until I'm able to get that doctor's appointment 2 months down the road to see if I can get some medical support for my claim.
Thank you. The next question is, if the accommodation request for a tenant is to move to a lower level of a market rent building due to mobility concerns, and there is available unit on the main floor, which is the same size as the unit, can the landlord change the rent rate based on the current market rent rate?
It depends. So I would say generally speaking, facing the landlord can make adjustments in rent, yes, based on, well, the size of the unit and changes in the unit and what you're requesting. So if, for example, your unit was going for a particular price and this unit is going for another price, the landlord can make the request and make some adjustments for the fact that the unit is different. But let's say that the units are the same. You should not face a disadvantage per se from requesting accommodation. But if the landlord can show, for example, that your unit based on its location, based on your unit is designed as, for example, rent to gear, it's designated as that, or affordable, quote unquote, affordable unit. And the other one on the ground floor does not have that designation. And there is, likely significant loss or disadvantage or hardship that will come from transferring you to that unit, then that could be something the landlord accounts for in assessing whether or not to give you that transfer. But if all things are the same, telling you that they cannot do the transfer because they're going to lose $200 a month in rent probably would not satisfy the test for undue hardship. And a landlord should really consider that and accommodate you as best as they can. because it may in the end up cost the breach, you're right, may end up costing them more than that $200 that they'll be losing per month.
Thank you. So the next question has a few details that I'm going to share, which can help maybe understand it better. So this is coming from a community worker who works for an organization that provides supporting housing supports for people with disabilities, primarily, I think, people using wheelchairs and requiring assistive devices with daily and assistance with daily living tasks. They work with landlords within the city to have certain number of apartment units within a building, and I believe their accessibility, they have accessibility features. The landlords still remain the owners of the unit, and there's a certain situation where a person with a disability has moved out of an accessible unit, and once they have vacated the unit, the landlord has raised the rent to market value. So, most of the clients that this organization works with are on ODSP, and the shelter allowance is quite low. So, their clients are not able to afford the market rent. And at one point, the landlord has removed the accessibility features such as ceiling, lift tracks, etc., to rent to a non-disabled tenant at market rent. And so in your from your advice, is there anything that you would like to share in this case? And especially with regards to a landlord reversing accessibility features. Is there any legal recourse in this?
So there's not a prohibition against the landlord reversing accessibility features. So generally speaking, remember those features, for example, are intended to provide accommodation to the tenant that is in the unit. So the accommodation that I receive does not automatically transfer to the next person that occupies my unit. It's person specific. That's what accommodation is. So whenever I leave, yes, the landlord can strip the house, bring it back to the bones, and start from there. It's a totally different, though, which would be a matter of contractual arrangements between the city and the other persons you spoke about and the landlord, if reducing the number of accessible units, if that's a breach of the contractual arrangement between those parties. But as a matter of human rights code and principles, there is no prohibition to reversing accommodate the accessibility features. Now, the question as to whether or not you can request to move to that unit, it depends. Remember, it still goes back to undue hardship. The landlord has taken out the accessibility features. If they took it out before they knew you needed the unit, that would be something totally different. If they took it out after you've requested to use that unit, then that's really on them, right? They made that modification without properly investigating and determining your request for disability. So there's that. But also, if moving you to that unit and then stripping down your unit, moving those items over would not be unduly hard, then of course, that is in your favor, supporting your request for accommodation. If converting your unit to the basic unit where they've taken out all the accessibility and it can still rent for the same market rent, then of course it will also support your claim for accommodation where the landlord could not claim undue hardship because the other unit is, less attractive and rents for less. So these are all things to consider in determining whether or not you want to press your case to move to that other unit and for the landlord to reinstall or transfer your disability accommodation modifications to that unit, depending on how much that's going to cost.
Thank you. The next question is, if a landlord is refusing snow removal from door to sidewalk because the tenant has a ramp, um, but the landlord provides snow removal to other properties and has said that the subcontractor is refusing due to liability. Is this situation worth escalating to a human rights complaint?
It depends. So the two things I got from that. So there is the general requirement to provide snow removal as a landlord under the Residential Tenancies Act. So that's not even a human rights thing just yet. It's a basic landlord obligation, or under the regulations. All right. Now, if the landlord, but from what you said, the landlord is willing to do it, finding a contractor that will take it on, that is the issue. Now,
Correct.
remember, the tribunal interpreting the code looks at the reasonable steps taken by a landlord to discharge their duty. So if a landlord has taken all the steps to identify a snow removal company within the area and can find none, it is less likely in my mind that an adjudicator will say that they breach the duty to accommodate, because they have done all reasonable things to honor their duty and to remove the barrier that you face, but they're just not able to do so because third parties will not take the job. So the failure to remove it in and of itself would not be a breach, so long as they can show that they took reasonable steps to deal with the issue. And then the other question is whether the snow removal or the presence of the snow otherwise presents a barrier to you coming in and out. So if, we're able to clear a path, or based on where you park, you only get over a small hump to get into your car, so it doesn't otherwise, it's a little bit inconvenient, but it's not a barrier to you using and accessing housing, then it's probably will not be in breach of the duty, or the landlord would likely not be liable. So it depends on how much steps they've really taken to remove that barrier, and if it's really a barrier to you using and accessing the place. Generally speaking, though, if a third party refuses to take the job because of the ramp, then it's not the landlord that is refusing to discharge their duty to accommodate, because the landlord cannot compel a third party to take a course of action. So keep that in mind. So they're less likely to be liable for that, even though it is clear that it's the ramp, which is the disability modification, that is the result of that third party not taking the work.
Thank you. If a tenant requires an air conditioner to be installed to address a medical need, and this is supported by a doctor's note, however, the landlord is denying the request due to financial reasons, what recourse does the tenant have?
So your request for all requests for accommodation is the same. If it's accommodation based on a code-related ground and you believe that the landlord is in breach, then it is, of course, a human rights issue if it's code-related ground. I always say, though, practically speaking, you look at the more immediate solutions around you. For example, depending on the city you're in, many cities, I believe the city of Toronto had it recently, and it only recently expired, where they would assist you in cooling mechanisms, for certain qualified persons. I know other cities have that in place, so they'll assist the landlord in bringing in cooling mechanisms, like AC and those things within the unit. And the usual requirement is that, the tenant has a lease that lasts a certain period of time. So that's usually one of the requirements. That may get you a longer lease in the house if you want to stay there a little bit longer. But the landlord can refuse, because generally speaking, there is an obligation to provide heat, but strangely speaking, there isn't an obligation to provide conditioned air. So the heat, you can compel the landlord to install, and you can do that through different city agencies much quicker, or even the landlord and tenant board, than going through the human rights process. So take a look to see what your resources are within the city. And some cities are, in fact, now considering AC bylaws, cooling bylaws, where, in addition to providing heat, you should be providing conditioned air above certain degrees. So take a look to see if your city is one that has a requirement. And then it would be complaining to the property standards division of your city to get the landlord to install cooling, which might be much faster than the human rights tribunal.
Thank you. Another question is with terms of disabilities. Is it mandatory for landlords to provide a fob key to enable persons with disabilities to be able to open heavy doors and entrances and when entering garages?
So it's not mandatory to provide it, but if it's a request for accommodation based on your disability needs, then you now need to prove to the landlord your need, your limitation, which is being unable to pull the door based on your being in a wheelchair, for example. How do you pull the door being in a wheelchair? I can imagine that must be very difficult. So you would be showing the landlord that you have that need and limitation, and this is why providing you with that accommodation is necessary. But across the board, there is not an obligation to provide a fob or that kind of controlled entry or assisted entry. But under the Accessibility for Ontarians with Disabilities Act, there is some of the regulations, there is obligation there, generally applying to commercial premises or even commercial landlords to put these things in place. But it is, if I understand it, impose less of a burden on a small landlord who is just renting, for example, a room in their house to put that kind of mechanism in place, right? But for large scale operations, certainly they do have the obligation. So it depends on your living arrangements as well. But that's not it's sort of a quasi human rights issue, but it's also independently an accessibility issue under the AODA.
Thank you. And we do still have a few more minutes. And I see that there's a hand up in the audience. If you can just please put your question in the Q&A. If you have a question, then I can address it. So thank you so much. The next question is, this is a new question that came in. The tenants who live for a long time in a building apartment and pay higher rent than the landlord offers to new tenants, and this causes a tenant to face economic difficulties, support documents that show cannot afford to pay. Do you think do you want to take a look at the Q&A box for that question? Maybe you can rephrase that.
Okay. The tenants who live long in a building apartment pay higher rent than the landlord offers to new tenants, and these tenants face an economic difficulty and request decrease rent and provide supporting documents to show that they cannot pay. Is that a right? I'm assuming this question. So
Yeah.
no, there is not a right to a lower rent. And there is not a right to special treatment because of your financial circumstances. There can be discrimination if you are treated differently because of your financial circumstances, for example, receiving social assistance. So if you treat me differently because I'm on social assistance, that can ground a claim for discrimination. But I am not entitled to getting a rent reduction because a unit downstairs went on the market and came in at a lower rent, or the landlord is offering that at a lower rent. So no. The question is, are you able to transfer to what? I don't know how the transfer would work in this situation, but to answer the question, no, you don't have a right to a lower rent because of financial circumstances. And the code allows landlords to take income into the equation when assessing credit worthiness or at that point, but they're not expected to look at your income otherwise and determine whether or not you should continue to occupy your premises. Save and except in rent to good income situation where the provider of your subsidy can look at your income and determine whether or not you still qualify for that subsidy. But the landlord themselves are not to be amending your rent because of your income unless it is a rent to good income arrangement.
Thank you, Demar. And this is going to be our last question, which is not about tenants, but this is about homeowners. As a condo owner, does the condo board have to take into account the accommodation of a particular owner as it applies to common areas of parking arrangements?
Yes, so the condo has an obligation where the common facilities are situate, or the management of common facilities, to also give that kind of accommodation to owners. So it's not just tenants. So everyone who uses or reasonably uses the common area is entitled to accommodation. And so as an owner being in that building, because the code says the right to occupy. So whomever has the right to occupy the unit is entitled to accommodation. So if it's owner occupied or it's tenant occupied, they both enjoy the benefits under the code.
Thank you. Well, thank you so much, Demar, for answering all the questions, and thank you for all our participants for asking such detailed questions from a wide variety of topics. So we want to thank you so much for joining today. And if you have any more questions, Demar's information, as well as the information for the BLAC Legal Action Center, will be in the slides, which will follow after the presentation is over. And you can always connect with Demar, or if you have any questions regarding the webinar, you can always reach out to us at our email address. So before we, end off, I do have some slides that I want to share. But before I do that, just want to say a big thank you to Demar for your presentation and for delivering this two-part series, which has been extremely, extremely informative to not only us, but also our attendees across Ontario. So thank you so much for bringing so much expertise and knowledge to this area. So I'll go ahead and I will share my screen once again. So if you could just give me one moment, and this will share in 1 second. Okay, well, you can see that we have a few resources for you here today. So Clio has 3 areas, which is Steps to Justice, the Guided Pathways, and the Clio Connect. So our Steps to Justice website has information on over 700 frequently asked questions, as well as our Guided Pathways online tool that can help people complete legal forms. If you have questions regarding asking your landlord for accommodations, you can always go on our website, and in the search bar, you can write accommodation and landlords, and you will find many resources which will appear and questions that you can find answers to. You can also access recordings of this webinar as well as past webinars on the Clio Connect website. The link is there. And just a reminder to everyone that you will receive an email with a link to this recording within a week, and a copy, which will include also a copy of the slides as well as our resource handout. Along with this, you can also find some information regarding legal services that may be helpful to you, including how to find your local community legal clinic and access legal aid services. Your clients can also contact the Pro Bono Ontario or the Ontario Legal Information Center. We have some more tools and resources that you can access. You will have a copy of this in the slides, as well as the resource handout page that you can access later. Some more clear resources and past webinars with regards to human rights and accommodation. And thank you again for joining us. And please take a moment to complete the webinar evaluation, which will pop up when you exit Zoom. If you have any questions, you can contact us at info@clioconnect.ca. So finally, thank you very much, everyone. Thank you, Demar, for being a wonderful speaker. Thank you to Helen from the Clio Connect team for providing tech support today, as well as our AirSL interpreters, Nicole and Lori, for being with us today. And we look forward to seeing you at our next webinar. So please stay tuned and have a wonderful day. Thank you so much.